side will, excuse me, each side will have 15 minutes to present your arguments to the court. And the appellant may reserve up to 5 minutes. Just please let me know. You may proceed.
May it please the court, my name is James Lane. I'm here on behalf of the appellant, Heidi Carroll. I would like to reserve 3 minutes for rebuttal, if I could, please.
Thank you,
Your Honors, we're here today on a post-decree modification of a shared parenting plan and a child support order. These parties have a long history of litigation between them. This case was decided approximately 2 years ago now. The issues in this case were relatively straightforward. What was surprising and where the trial court, I believe, lost their way was modification was sought by the father in this case a mere 8 months after the parties voluntarily entered into a shared parenting plan. The court, for some reason, made a determination that a change of circumstances had occurred in that very short amount of time to justify a significant modification to the parenting time schedule and also to the child support order. I've set forth 5 assignments of error in our brief. I'd like to address the child support issue first, if I could, which I believe is assignment 4, because I think that's where the court most obviously lost its way. The child support order in this case was in reference to a modification of 2011, 2012, and 13, or sought a modification for those years. The trial court only modified for 2012, and they made a couple of what I believe were egregious errors. First, this is very clearly a case in which the parties' incomes exceeded the $150,000 combined income level. The Ohio statute is very clear under 13CA0190B. Whenever you have a combined income in excess of $150,000, and these folks were significantly above that amount, the court has to do an analysis under 13CA0190B in regards to the needs of the child and the lifestyle the child would have enjoyed had the parties stayed married. The court did not do that. The court didn't cite to the statute, didn't do any type of analysis whatsoever related to that statute. They simply did a straight guideline child support calculation, capping the income at $150,000, which also didn't make sense because this was a somewhat complicated procedurally. They issued an order originally granting all of or approving everything the magistrate did, which included a calculation of child support extrapolating up to the full combined, including all of the combined income of the parties. Appeal was filed, the objections were filed at the same time, the case was remanded back to hear the objections. On remand, the trial court decided now we're going to cap combined income at $150,000 and change the way we calculate child support, thereby reducing the support order by several $100s without any explanation or without any justification for why the full combined income of the parties was not considered. And certainly there wasn't a 13CA0190B analysis. Just as important, I believe, was the court's complete failure to look at my client's work-related daycare expenses for the child. The parties stipulate that she had approximately $32,000 of work-related daycare expense. And I cited it in the brief, and it's obviously in the record. There is a stipulation on the record that she had $32,000 of daycare/nanny expense. And somehow the trial court determined that they were not going to include any of that in the child support calculation.
Was it ever broken out how much of that pay, from what I read in the brief, she also did other things like housework and, house cleaning and other things that she did that weren't child care related.
Sure.
Was it ever timed out?
It wasn't, the she was paid on a weekly basis. I think it was, I don't recall what she's paid per week, but it was,
$600.
it was $600 a week, thank you. And she wasn't able to break it out. What she testified to was the vast majority of her time was spent simply caring for the child. When she was there and the child, for whatever reason, didn't need her, she would do light housekeeping, and she would occasionally do some shopping. And that's what she did. But her testimony was that, the vast majority of her time was spent caring for this child. And at the time she testified, the child he would have been 5 at that time. So in the years we're talking about, he would have been 3, 4, and 5. So obviously a child that young needs a lot of care. He was there almost the entire time that she was with him.
He wasn't at preschool at all? He didn't
No.
attend preschool?
Not up until the time when he had just started going when we went to trial, which was in 2013. So at that point, for the years in question, 2011, 12, and 13, the vast majority of that time he wasn't in preschool. He was there with her. And the few times when he wasn't, that's when she would be able to do a little bit of light housework and so forth. But the vast majority of her time was spent caring for this child. And certainly the court has the ability to determine if the amount is reasonable or not. No one's questioning that. And certainly there's an argument to make that $32,000 for daycare of one child is too much. Fine. That's fine. I'm not arguing that the court doesn't have the ability to look at that and choose a reasonable number. What it can't do, and was exactly what it did, was completely ignore the expense. The case law is very clear, the statutes are very clear, I cited in my brief. The court, it's abuse of discretion to ignore and not include in a child support worksheet any work-related daycare expense. He testified, I'm sorry.
The court, trying to recall from the briefs whether the court reasoned that during that time, mother was at home, was working from home.
That was not what the court said. There was a small period of time for about 6 months in 2011 in which she was working from home as a contract attorney. She's an attorney. In late 2011, 2012, she got a full-time job working at a hospital. So there was never really any question that she was home or that the daycare wasn't needed. And that's not what the court said. The court's position was the expense was unreasonable and she did some other things besides daycare. Therefore, the entire expense is mom's obligation. And we're not going to include any of it in the child support worksheet. The case law and the statute says you can't do that. He testified in court that he believed, I believe the number is $10,800 a year, was a reasonable amount to pay for daycare. At a minimum then, that's the number the court has to use. If he, who's challenging this, says that's a reasonable amount for daycare, and we know the expense by stipulation is significantly higher than that, then at a minimum, that's the number the court should have used. Instead, they used 0.
So, husband was arguing that, let's assume, as you say, he said, well, $10,000 would be reasonable. But under these circumstances, the nanny was providing only care at her home, was not communicating with him.
He claimed it.
Could the court have taken that into consideration?
It wasn't something.
Recently?
I can't say what they did or didn't do as far as mentally, but what they cited in the record was nothing related to that. When talking about this expense, the only justification that the trial court provided for requiring my client Heidi to have all of this expense obligated to her was the fact that the amount was too much and that the nanny did some other things besides daycare expense. So it did not reference the issue of working only from her home. And to address that issue, and this becomes an issue later on in the modification of time as well, the parties agreed when they entered into their shared parenting plan. They named this specific caregiver, said this is going to be our nanny, and they agreed, and he admitted in his testimony, she's going to work from Heidi's home. There was never any agreement or any attempt by him until we got to trial to ask her to work out of his home. that was never contemplated by the parties, nor is it something that he even asked for until we got to the day of court. So that is a completely disingenuous argument he has put forward, this idea that, well, because she only worked from Heidi's home, therefore this is somehow not a reasonable type of daycare. He agreed to it. This is what he agreed to in the shared parenting plan. And he stipulated that this was the expense that she was paying for daycare. It says it right in the stipulation, daycare expense, $32,000 a year. The court also failed to include all of his income. He was at the time also teaching, he works at Cleveland Clinic as an executive, also was teaching at a local college, earning an extra, I believe, $18,000 a year.
But I thought I saw that on the worksheet.
It did it for 1 year, and then it said it was, well, originally it was on a worksheet. Then the court on remand decided that because he didn't admit that he was going to do it a second year, he said he had applied, but he wasn't sure if he was going to get the job. Well, he did get the job, but because he said he wasn't sure, the court said, okay, well, this is a non-recurring income, and therefore we're not going to include it.
When you say he got the job, is that going to be in the record before us?
This happened, no, because this happened after the record was closed.
So we can't consider it.
Well, I think you can consider it because the testimony was this was a job he had for sure in 2011, and that he had applied for the job again in 2012. And the expectation was that this was going to be an ongoing thing. Had he not applied for the job and said, I did it for 1 year and I'm done, fine, it's a non-recurring event. But it wasn't a non-recurring event. It was an event that continued on in which he continued to earn the income. For that reason, I think the court can include it. But I think the two primary errors the trial court made when talking about child support were in failing to use 31-1904B to analyze the income and failing to include the expenses for work-related daycare. Would also.
Counsel, you're at your 3 minutes.
Okay, thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Please the court, Attorney Andrea Burdell-Ware, here on behalf of Robert Kenney. I'd like to start by giving an overview of what we think the case was really about. This case was really about the sharing of a child, and it's the only child of the parties. Neither parent has any other children by any other person, and this is their only child. Although both Mom and Dad filed motions to modify, it really felt like when we went to this trial that Mom's motions to modify were all related to cutting off Dad's rights under the shared parenting plan, thereby effectively gaining what would be custody of their child without actually terminating the order of shared parenting. In other words, trying to strip those rights without taking the risk of maybe losing custody herself for the arguments she made. I think this case was about Mom wanting the court to modify a plan, but only when it aligned with her desires. She makes no effort to co-parent with Dad, which was evidenced by her request and the very issues on this appeal. Mom once sought to modify the exchange location in the case. The court, in fact, modified the exchange location, and then Mom took it up on appeal because she didn't want it to where the court modified it. Mom unilaterally enrolls a child in preschool that's miles away from both parents' households. The record reflects that Mom lives in Valley City, Dad lives in Middleburg Heights. Both parties, when this case goes to hearing, both parties work in downtown Cleveland. What happens is Mom chooses, here's Valley City, Middleburg Heights, Cleveland. Mom chooses a daycare provider way outside of where anybody works, outside of where she lives, outside of where Dad lives. And I would suggest to this court that was another way for her to control what was going on. She knew that they both worked in the same general area, that you could pick a daycare provider that could be convenient for all. We all know there's probably a gazillion daycare providers, but instead Mom chooses to take the child to a daycare provider that's really, really far out compared to where they work.
But this was a preschool.
It was a preschool, I apologize.
No, I just want to make sure, because to me, there's a difference.
There is a difference, and I
You picked
misspeak.
the preschool for different reasons, maybe.
Correct, and in fact, she did. The record indicates that. So at any rate, though, she picks this preschool that's nowhere near any of them, when it could be so easy to co-parent and pick something between some general location they all
But she
share.
had that preschool as part of her church?
Well, she got the church to pay for the preschool, it's not part of her
Okay,
church.
But I mean, I'm sorry, I misspoke, but the evidence does demonstrate that it was paid for by the church,
That is correct.
that she got some kind of
Scholarship, yes, Your Honor. In addition, though, the shared parenting plan said that the child would be enrolled in preschool when age appropriate. There's no dispute about that. The bottom line was, neither of them could agree. The testimony indicates Dad wanted something kind of centrally located to their homes and their jobs. So he had chosen a place in Strongsville, and in fact, when Mom found out, she unenrolled the child. She unilaterally unenrolled the child, and that was the end of it. Child went to preschool. Court did not rule on either of the parties' motions to prohibit the other from enrolling the child. Rather than continue to tear the child in half, Dad, I guess to some extent, concedes, because the child at this point is in preschool in Medina. Not that he agreed with it, but at some point you just have to stop, and so he did. With regard to the nanny, Mom used the nanny as a tool to gain and maintain tight control of their one and only child. Mother's use of the nanny provided her yet another opportunity to not co-parent and to keep the child from Dad. And you can see when the judge reviewed the case back on remand, the judge recognized what Mom was doing with the use of the nanny. The other point with the nanny, though, is a parent without a nanny chooses a preschool that has some geographical proximity to where life goes on. But when you have a nanny, she was able to take that nanny and pay this nanny to take this child further from the parties, in the complete opposite direction of where they had everything going on. I think it's important to note in Mom's brief, the appellate brief, that her statements of fact that she provides, they provide almost no references in the trial transcript or citations in that portion. I suggest to this court, because they're not supported by the record, so I would just ask this court to be very particular about taking as fact anything that's stated as fact that is not cited. For instance, Mom states that she had an obligation to enroll the child in preschool because she is the residential parent for school purposes. She is in fact the residential parent for school purposes. She was not obligated to enroll the child in preschool that she chose. She was obligated to talk with Dad, and they were supposed to come together on it. So I point that out because it's just patently untrue. It's a misstatement. Likewise, in her brief, she misstates Father's parenting time pursuant to the original decree. Father not only had the time that she cited in her brief, but when you review the prior allocation, Father had a bunch of additional time. Both of them did. They had this thing where they go every quarter and get like 2 weeks of additional parenting time. In addition, Dad could elect to keep the child when, for instance, at 8 in the morning when his parenting time would end on a weekday. If he was going to be otherwise available, he could just tell Mom, hey, I'm keeping the child because I'm not going to be at work. So his parenting time automatically extended, could be pretty frequently. So while the brief characterizes the parenting time change as dramatic and outrageous, it really amounts to about 2 overnights a month. Not really very dramatic when you consider all of Dad's other parenting time that was previously ordered. With regard to the child support, I guess before I move on to that, counsel indicated, within 8 months, Dad files a motion to modify. That is technically correct. I would suggest to this court, though, that it was not only 8 months, but it was another 1.5 years until the matter got before the trial court. Roughly 1.5 years. I didn't count the days. So the case actually pended 1.5 years plus the 8 months. So we're talking about a 2.5-year change at the time this court, the trial court gets the matter. And lots of things have happened at that point. With regard, Your Honor, how much time do I have?
You have 7.5 minutes.
Thank you. With regard to the child support calculations, first of all, the $150,000 plus, council indicates that the trial court had an obligation to consider the child's lifestyle, all those things that relate to the expenses of the child. I submit to this court, and I briefed in this, that as counsel in that case, I specifically attempted to inquire about the lifestyle of the child, the expenses necessary, and mom's counsel was not going to hear it. It was objected to. They objected to the introduction of that evidence. So I don't think it's now fair to say that you didn't let the evidence in, but now you're going to complain that the trial court didn't consider it. If you have invited that error to occur, if you would call it an error, I'm not sure that you would, but if you've invited that, in fact, made that happen, you can't now complain about the fact that it happened. As an additional basis to cap at $150,000, the original child support award in this matter capped at $150,000. I would suggest to your honors that that is a deviation from child support from day one. That was an agreed upon deviation for these parties. They knew they could consider other things. They didn't want to. They chose not to. And it would be mom's burden to show why that should be different when we come back. She had the burden to show why suddenly we should change that deviation. With regard to the nanny/daycare expense, there's a stipulation for nanny/daycare expense. I think there's one for each time period. I would direct this court's attention to the original decree. The original decree, shared parenting plan, says that mom can hire a nanny if that's what she desires. Mom's not working, if she's going to insist on a nanny, okay. But it also says that it's at mom's expense. She had the nanny when that was agreed to, and the expense that was allocated to dad for her insisting on having a nanny was nothing. Again, as a parent, I think you have to cut your losses, and you go, well, look, she is just dead set on this nanny stuff. So his concession was, okay, we'll use the nanny, but if you're going to insist on this crazy expense, you're going to pay for it. And so that was their concession in their original decree. And so,
that was while she was not working.
well, she had a nanny while she was not working. She paid
That's what
that.
I'm saying.
Yes,
So
Your Honor.
the original premise was she wanted a nanny to take care of her child when really she could be home taking care of her child. So the original premise was you want a nanny when you're not working.
It could seem that way, and frankly, it may be that way, Your Honor. I'm just not sure why. I don't think the record, any of the stuff really reflects why she insisted upon incurring this expense even when she wasn't working. I'm just not sure.
But
Go
there
ahead,
was,
go right in.
there was some reference, I thought, in the brief that while she was a contract worker and was able to work from home, that she had appointments that sometimes required her to leave home.
That could be accurate, Your Honor. There was, it was kind of succession. My recollection is that initially she wasn't employed at all. She wasn't doing contract work or otherwise. I believe that's what the record states. And then at some point, she starts doing contract work from home for some amount of time. And then that progresses into her obtaining actual employment outside of the home. So there's a progression. My point, though, is the expense she already incurred, the expense that she chose to incur without any need, doesn't change when she decides that she now wants to work. It doesn't become something other than it was. She didn't incur expenses because she went to work. She already had those expenses. There's something that already existed, so when she goes to work, she doesn't get to come back and go, oh, well, now I want to allocate part of this to you. We had an agreement. The agreement's in the shared parenting plan. You choose to hire that nanny. That's good.
But I guess what I'm not quite getting, if you decide then to go to work full-time, whether you have a nanny or not to begin with, that full-time employment inures to the benefit of the other spouse, right?
Well, I guess it depends on how you look, because it was a concession on Dad's part. I'm not sure it really inured to his benefit at all. It was, again, as the trial court pointed out, a way for mom to continue to control the situation.
I'm just saying, no pun intended, divorce yourself from these circumstances. Let's just say, in the general case, if you have two people that are divorced and there's child support being awarded to one spouse based on the income at the time, if there's a deviation, 10% deviation, whatever, there's going to be possibly a difference in child support.
That's correct, Your Honor. My only point, I guess, really is that nothing changes when she goes back to work because she doesn't incur work-related daycare expenses. Coincidentally, she's already hired a nanny for when she doesn't even work.
I thought the argument on behalf of mother was that it was always anticipated that she would go back to work. So if you go back and look at the statute, it is those things that are unanticipated, when we talk in terms of a change of circumstances.
That doesn't change, I would submit to you that that does not change her expense. The other thing is, I do not recall that's being in the trial record. I could be wrong, but I don't recall it being addressed, whether or not she anticipated going back to work. It would seem logical that we would anticipate that, but I don't think that's in the record.
Oh, I know it's in the brief.
It may be in the brief, but again, if it's not cited, I would be cautious about relying on that. With regard to Dad's income, the trial court specifically found that the $18,000 was not reoccurring. In fact, it could not have been a reoccurring income for Dad. It was the first time he had ever done it. He testifies in the trial that he wanted to try and do it again. He applied to do it. Whether or not he would actually be able to do it, we would see. I'm not really sure. I don't know if I need to object, but it appears that this court may consider evidence not in the record as to Dad's subsequent employment.
Well, you can rest assured we will not do that.
Okay, well then I won't continue.
That is not what we can or ever do, and we will not do that.
Okay, so thank you.
But the point is, the point is, I think the argument is, again, well, he applied, so what is the remedy? If he had received it at one point, you're saying that doesn't mean it's recurring, but if he applied, you're to assume that he's not going to receive it?
We didn't know whether he'd get a job again. To the extent we're going to discuss this, in fact, the trial court, I believe, said, look, if this turns out to be reoccurring income, come back. We will, in fact, put that income on Dad's side and adjust child support. In fact, it only happened once. Thank you very much.
You have 3 minutes and 2 seconds.
Thank you, I'll be quick. Robert testified that he knew Heidi was looking for a job when he signed the shared parenting plan as cited in the transcript, April 8th, 2013, page 216, April 5th, 2013, page 134. The reason she had a nanny when they entered into the shared parenting plan in September of 2011 is because she was unemployed for a very brief amount of time, and she knew she would be looking for a job during that period of time. The only reason she agreed she would be the only one to pay for it is because, technically speaking, she was not employed at that time. She's aware that the law says that daycare expenses, when you're not working, are your own obligation. There's a huge difference. Counsel said there's no difference in the expense. It doesn't change the expense. It absolutely changes the expense because the law specifically says work-related daycare expense is to be included in the child support worksheet. It says it has to be included in the child support worksheet. That's the huge difference. You can pay for all the daycare expense you want, but unless it's work-related, it's not to be considered in the child support worksheet. When she started working full-time at the end of 2011, that's when that daycare expense became a work-related daycare expense, and that had to be included in the child support worksheet. It's a huge difference. And the fact that back in September of 2011, she agreed she'd solely pay for it does not by any stretch of the imagination, nor is there any case law that they can cite or statute that says that because she agreed to it in September of 2011 when she wasn't working, she no longer is entitled to any work-related expense reimbursement. That is absolutely not the case. I'd like to address the custody issues real quick if I could. There is no change of circumstances in this situation. There was no evidence of a change of circumstance. This court unfortunately got caught up in making a determination for this child of what was best for father as opposed to what was best for this child. Father testified on cross-examination when I asked him, how's this child doing under the current order? His response was, he's doing great. He's perfectly happy, perfectly healthy. He's doing great. He's perfectly happy, he's perfectly healthy. So why are we changing this? There was zero evidence that a change to this custody order would in any way benefit this child. None. And there was no change of circumstances. The situations or the facts that the court cited for change of circumstances simply did not support it at all. Her going back to work, which is one of the things, the main thing they cited, is not a basis for a change of circumstance. It didn't open up more time for him because he works full-time as well. His claim that he has a flexible schedule, the facts do not support that. He has never made himself available during the day because he has a full-time job, understandably. That is not a change of circumstances. The use of the nanny was exactly as anticipated when they entered into the agreement. A change of circumstances has to be something that was not anticipated by the parties. Any change, if you can call them changes, were completely anticipated by the parties. The child going to preschool when he's 3.
Counsel, you're out of time, I'm sorry.
Thank you, Your Honors. Thanks for your time.
The court will take the matter under advisement and issue a written opinion that will be sent to both parties, and you may check on our website as well as the Supreme Court website, because we will also release it electronically.
Thank you.
Thank you very much.
Thank you.